Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here, we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. Leah, welcome to the show. How are you?
Very good. Thank you so much for having me.
Well, it's great to have you for so many reasons. Brandon and I are excited to talk with you today about various different topics. But before we get going, I know a lot about you, but I'm certain that not everybody knows about you and about your background. So maybe go ahead and get started in your own words, as opposed to me rattling off all of your qualifications that you got, which are numerous. If you could tell us a little bit about yourself.
Sure. I work at Robbins, Geller, Redmond & Dowd, which is a plaintiff's firm that focuses mainly on securities class actions. We also do some antitrust and consumer fraud cases as well, but we are totally plaintiff's firm. I'm based out of San Diego. I've been here for about 12 years, and I focus 100% on eDiscovery issues at the firm. I'm the only person at the firm who does what I do, and so I work on all of the different cases across all of the different offices and different practice areas on eDiscovery.
Suffice it to say, you are keeping yourself busy, it sounds like. So there's a lot to unpack just in what you said about your introduction. And one of the things that's interesting is that a lot of the people that Brandon and I speak with, whether it's the podcast or in our, respective professional lives, is that we usually speak to folks that are on the defense side. And, I shared before the recording that I've got a fondness for the plaintiff's bar because when I graduated law school more years ago than I would like to admit on this recording, I made a choice. I went right to the plaintiff's bar. And for me, I felt like I had a need to protect others. And I thought that I needed to help tell their stories. And if I could help tell their stories and provide justice to them, that was great. That was before eDiscovery became eDiscovery, of course. Back then, it was just paper boxes. And as I think about talking with you today, it makes me wonder about your decision about going into the plaintiff's bar. What was the thought process for you? Because it is different. What was it for you?
I never even wanted to be a lawyer at all. So let's start there. I took time off between college and law school, and I worked for nonprofits and schools working with kids who are in the juvenile justice system, either on probation or in the foster care system, and working with them in developing programs to try and keep them out of jail and keep them out of the foster care system. So when I went to law school, I went with that in mind. I wanted to try and protect these kids. And so I went for more a policy. I wanted to do policy work when I got out of law school. I did not want to be an attorney. My father was an attorney. I saw what that looked like. I didn't want to have anything to do with it. But then there was, the crushing debt that followed law school. So I went straight to the defense bar because that was easiest. I went to law school in New York City. In my mind, that was all that existed. It was working for the ACLU or there was the defense firm. I did not know that there was anything in between. So I went to a defense firm and worked there for 3 years. And I learned a lot. Like it was a very good experience to have, but it was definitely not where I belonged. It was not the kind of work I wanted to do. To credit them, when I said, this was during the recession and I was on a big pharma case. And they were firing everyone because, there wasn't any money at that time and there wasn't any work. So I was on this big pharma case, and I went in and I said, I was one of the few remaining associates out of my class. And I was like, I need to get off of this big pharma case or else I'm leaving. And to their credit, they took me off of that. They put me on smaller cases where I got better experience. And I was still defending corporations and very rich people, but it was a different sort of case. So I appreciated that. But still, I was there for a few years. And the moment I got to a comfortable level of debt, I left and moved back to San Diego. Still didn't know that the plaintiff's bar really existed, didn't think about it at all. And I ran into someone who I had worked at the defense firm in New York with, and I was taking the San Diego or the California bar in San Diego, and she was there, and she had left maybe a year before I did, and was taking the California bar. She told me about this great firm she was working at and how different it was from the firm that we were at in New York, and that I should try and get a job there. So I started at Robbins Geller and did my first case was a securities case, and they were trying to do predictive coding. And so I started to learn all about predictive coding. But when I got here, immediately it made sense to me. Like this was what I wanted to be doing, and being able to fight against the big corporation. Like you said, Dan, like giving a voice to people who are not normally heard. These corporations that we go up against are like the biggest and the baddest, and they comes with that incredible resources and entitlement and privilege. And to be able to go up against that and say, no, you can't do that. This isn't right. And to not be scared of their enormous power that they have is amazing. And so to work in a place that really embraces that, and everyone here is like incredibly passionate about what they do, which is very different than on the defense side. I mean, there were some people who drank the Kool-Aid on the defense side, but those were kind of scary people. But for the most part, everyone here is like super into what they're doing and are fully committed to the cause. And that really is the difference in trying to, and for me, like even the e-discovery part of it fit, even though, again, I didn't know e-discovery existed when I went to law school either, but trying to find the facts. I mean, really all of our case is made up out of what they give us, and trying to find the things that can then make our case and get to that truth is incredibly important. And so I really love being able to advocate for that. And my firm is like really they were pioneers in this part as far as having an e-discovery attorney. I think they were probably the first of the plaintiffs' firms to have a dedicated e-discovery attorney, and understanding the importance of that to be able to make our case. So it was a game changer. I never thought, I came here as, I'll figure out what I'm doing. I'll stay here for a year or two, but I really kind of found a home. And understanding all the differences that, things like, rule changes in looking at the federal rules of civil procedure. And I'm able to both do, I sit and evaluate search terms, and I also monitor, what the rules committee is doing, because that impacts how we get our discovery, what we get, how much we get, the form we get it in, and then how we can advocate for our clients. So it's everything encompassed in that. And I'm not doing what I set out to do, but I still get to fight for the little guy.
Well, that's a great story about your career path. And it's fantastic to see someone who's got that kind of passion for what you're able to do and how you're able to leverage the law and the angle from which you're able to practice law. So I'm glad you found your great home. What I'm curious about, you say when you came in, your first matter, they were trying to use predictive coding. So it sounds like you were straight into the fire.
Yep.
I'm really curious about your growth in sort of the substance and the technique of e-discovery. That fact that the firm was one of the first to really see the importance of having an e-discovery attorney as part of the firm. How did that grow? How were you part of that? And what has been your passion about getting that deeply involved in e-discovery?
So I started out just working on a securities case. So I was not an e-discovery attorney when I started, but we were trying to force defendants to use predictive coding. This was, I think, 2012, I think. So back, right at the beginning there. And my job immediately upon starting was, well, what is this predictive coding thing that we're trying to make them use, and how do we do it, and how do we make sure that they're doing it appropriately? And again, our firm has a lot of great technologists here. Our lit support and e-discovery department is amazing. And so we had been using technology in-house to evaluate documents in-house. So we had a lot of experience already in different sorts of analytics. And so this was one of them. So just kind of got into it and was tasked with learning all about it. And then after that case, then they kind of saw the need. The person who was the partner on that case was sort of the e-discovery guru at the firm at that time, but he really wanted to get back to focusing on litigating cases. But there kept on being all these e-discovery issues that people would come to him for. And so he said, okay, well, Leah gets this stuff, so why don't we have her be the e-discovery person? And so was able to just focus on that, and come to find out there were a lot of e-discovery issues at the firm. And so was able to work on all of those. And so that's kind of how that all started.
As somebody who has become the in-house e-discovery expert, can you share what people may not realize or appreciate the perspective of how the plaintiff's bar handles e-discovery?
It's very different in that almost everything that we need to prove our cases is coming from someone else, and someone else who does not want to give it to us. There's nothing they can give us that is going to help their case. So their entire purpose is to give us as little as possible. So everything is a fight. So getting any documents at all, from the very basics of identifying custodians. I mean, we still fight about that sometimes. And so it is a constant struggle against delay and obstruction. So that's kind of how we come at it, is having to justify everything that we're asking for, even though in our minds we're entitled to most of it, but it is a constant obstruction. So that's how we come at it. And then in-house, people think we want everything, and we'll take everything. If it's, between everything and nothing, we'll take everything. But we need to analyze those documents quickly and effectively on our end. And we usually have far less time to be able to evaluate and get through those documents than the producing party did. We've got to be ready to go to depositions almost immediately upon receiving the documents. And we need to evaluate for deficiencies. There's a lot that needs to be done in a short period of time. So we use a lot of technology in-house to be able to find the best documents quickly, and to build all the connections, and to understand who's talking to who, and be able to build the story that we need to in a very short period of time.
That's interesting. Like Daniel said earlier, I think for both of us, we spent more of our time working in the field of e-discovery with defense counsel, and seeing the challenges and the strategy and the approaches of e-discovery from that side of the bar. I'm curious if you see from the plaintiff side what you think of as the strategic advantages of being a plaintiff, and what you can do with e-discovery, whether it's the use of analytics or whatever tools you might bring to bear. Where do you have a strategic advantage over the defense in how you handle e-discovery?
It's hard to think of it as an advantage, or maybe it's just the week I've had, but trying to fight for everything that we get. But once we do get it, it isn't the boring, is this relevant or is this not relevant? Like, everything that we get is relevant. And so then it's finding the nuggets in there that build the story, that can best tell the story, and putting it all together. So we get to focus on that. And it isn't just like looking at a bunch of junk and trying to separate the junk from the relevant stuff. So it's more fun in that way. And We can use things however we want in-house because we are not having to defend a production. And I get that. And I think that that flexibility is really nice, but it's to our advantage to find everything. So we do things the most effectively and the best that we can because our entire case rides on being able to find the documents that we need. And so, but we have incredible incentive to do that.
Mhm.
On their end, not so much incentive to find all of the relevant documents to hand over to us. So I think in that way, we do have the advantage because we really want to carefully look at and evaluate everything that we can, and we have to do it as quickly as possible.
You said a couple of things in that answer and your answer before that are curious to me. You are dealing with the fact that, at least in the practice that you have, where it's really asymmetric as far as the who holds the information. So you're sort of beholden to them, that everything you're going to build your case on is coming from their hands, but the processes are sometimes really opaque as to what defense counsel is doing and how they're collecting data, how they're reviewing it. What have you found to be the best tools that you can use to either get insight or sort of force their hand to help you understand what's going on in the e-discovery picture over the course of the process?
I am very much a process driven person. And I think there's a lot of sort of the mantra, oh, it doesn't matter what the process is. It's all about the results. So unless you can find a deficiency, it doesn't matter what we do. That obviously that does not work for us. And I don't think that is true at all. So I try and get the process, especially because I'm not staffed on all of these cases full time. So I come in and what I try and do is set up a discovery process that is going to work well. So, I'm a firm believer in ESI protocols, and within them, we go through, you're going to identify custodians, you're going to identify sources, you're going to identify search terms, or if you're using TAR, you're going to talk about that. And then we set up a process where we can hash out all of the potential disputes that we're going to have about the process ahead of time. There will be, substance disputes later on, but I at least want to make sure that we've got the process down. So that's usually what I do. I also very much believe in explaining the positions because I understand that a lot of the defense side will believe that, we're just trying to make things difficult for them just, because that's what we do. And we don't really have a reason for it. And that's totally untrue. I have never asked for anything that I don't have a firm belief that it is necessary for us to have. And so I do try and explain the rationale for why we want things. Why is it important that you disclose what sources you're searching? Why do we need to know that up front? And so that we can discuss it and they understand where we're coming from, with the hope that if they understand it, they will be more willing to comply with it and try and resolve the problems that arise instead of just causing all the problems. So that's kind of how I work through things. And I think that getting that, things like, disclosing sources, if I don't know what you're searching, and again, not all defense side is the same, just like not all plaintiff side is the same, but if I don't ask what sources people are searching, they're just going to go to email and that's it. And there could be a ton of other sources, but if I don't ask, they'll do the bare minimum. And so I need to constantly be on that, or else I'm not doing my job to make sure that the discovery is as robust as it needs to be from the beginning, or else it'll just lead to delay, which is the other thing that, again, defense side usually doesn't have a problem with the delay. So, but we do.
There's a lot of interesting things that you have hit on here, whether or not you realize you hit on it, Leah. And I want to touch on this. There's a lot of neuroscience and psychology and being a lawyer that a lot of people probably don't appreciate. You probably do. The perspective that you have, you probably understand that a lot. There's something about the words that we use as lawyers. Brandon and I both being lawyers as well. The words like adversary or arguments that we have to make. Or, and you said it a couple of times, fighting about custodians, fighting about everything. The words that we use have been built up over and over hundreds of years as being lawyers. I think, may he rest in peace, Judge Waxy here in Kansas. I believe he was one that actually said that he didn't like the phrase zealous advocacy, right? And I believe that the Federal Rules of Civil Procedure actually removed the word zealous out, not too much long after that. Do you think that if we change the words, it's almost like collaboration is a bad word to use, right? It makes everyone sound weak almost. But do you think if we change the nomenclature and suppose of being an adversary, it's just, maybe just, the other side, the other attorney, as opposed to doing arguments, we're just having discussions in court. Do you think if we changed our nomenclature that e-discovery may be more cost effective?
I mean, I love that idea. I think that that was the whole purpose of the idea of like cooperation, was that we were supposed to, and I read, the cases back, I mean, they're not even that old cases, but say, in 2006 to 2010, it was a lot about cooperation and getting to the truth. And that's what the purpose of discovery is. And I truly, truly believe that. And I am by nature a problem solver. And so I don't want to have disputes all the time. I do not want to fight all the time. That actually is not my natural state. And I wish that we could just go in and have discussions about things. And again, not everyone is the same and not every case is the same. And so that does work in a lot of cases where it can be much less adversarial in the way that people are very nice to each other. They're cordial about it, and there is some exchange of information. Whether or not the strategy changes, though, I don't know. So in a way, I would rather have people be true to form and showing that they are fighting up front, rather than doing it in a nice way, trying to lull some sort of sense of security. In a way, I respect sort of the genuineness of it. Well, still, of course, we all need to be more civil with each other. And I think this is a broader thing about society in general, that we need to be more respectful towards each other and understand. And I always try and understand the other side's position, and that's a really big deal for me, and I listen to what they say. But if I don't get a position explained to me, I can't solve the problem because you haven't articulated a problem. And so that's where I get more frustrated, when it's just no, 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 without a reasoning. I want to be able to come to a solution that makes sense for everyone, but I can't do that if no actual issue has been articulated, and it's just a brick wall. I hear you on that, and believe me, I would much rather just be having conversations about things. And if I did not have to articulate a need for why do we need custodians, why do we need sources, I think that things would go a lot smoother. It's when I get obstruction from the very beginning that it becomes hard to just have those types of conversations. That's why, I mean, things like a 26F checklist, things like that, where we don't have to start at the very beginning fighting over every little thing, would be extremely helpful, I think, in making people be a little bit more civil towards each other and have that exchange of information, because it is required or expected from the beginning. I think that would go a long way. But yes, I think I'll be more conscious about trying to change my language and see if that works.
Well, on a related question, it sounds like in a number of your answers that one of the challenges being on the plaintiff side of the bar and working in e-discovery is it's like pulling teeth. I'm constantly looking to get information from people who don't want to share information with me. I'm constantly looking to move things forward with a party who doesn't really care about delays. So there's this sort of that adversary nature comes from the fact that the motivations on the two different sides are very different from one another. But that doesn't mean that the practices and the processes that one side employs can't be useful on the other side. So I'm curious if you've seen in your growth in e-discovery, are there things that you feel like the plaintiff's bar does when they approach e-discovery challenges that the defense bar could learn from and maybe even help the process as you work together with things by learning some of the things in the way that plaintiffs approach e-discovery?
There isn't this, plaintiff's bar. We are all different and we all approach things in different ways and we all have different motivations depending on the types of cases that you do. Someone who does employment class actions is very different than what we do. So there are different approaches to things, but I think at least from what I see, is the having a rational explanation for everything that you are doing or need to do and are requesting, or reasons why you are refusing to comply with a particular request. Having those justifications and really articulating those, I think would be helpful for everyone. And I don't see that, I think, enough on the other side. And I think that's really where the breakdown comes from. And if someone has a reasonable explanation for something, I'm much more apt to listen to that and try and work with that as much as possible. There will be some things that we will not agree on regardless, but at least coming forward and making that effort to articulate it would be incredibly helpful, and have someone who's knowledgeable on the phone. I mean, I think the plaintiff's bar has gotten enough sort of criticisms of that we're not sophisticated enough in technology and we need to step it up. And I've done a lot of work. I mean, I work with an organization that does e-discovery education and advocacy on the plaintiff side entirely, and trying to raise the bar on that. But I'm still getting, on the defense side, I'm still getting the people who don't know what they're talking about and trying to negotiate a TAR protocol with someone who doesn't know anything about TAR and refuses to get someone on the phone who does, is incredibly frustrating. So taking a moment and just being like, okay, we don't know everything either, and get some experts in and trying to raise their level of knowledge as well would be really helpful.
That's interesting. Do you think that the overall cost of e-discovery would go down if we had more of a deliberate, conscious effort to say, you know what, actually, I don't know whether or not the custodians actually were accessing signal on their Android device. And by the way, I know what the data map looks like across the entire organization. And across that data map, there were, 16 different custodians utilizing off-channel communication, right? Like walking into an ESI protocol. And where I have heard in some contentious meetings, some people have said it's like having a battle of wits with somebody unarmed, and that what happens is that it could potentially increase the overall cost of e-discovery for everybody, for you as well, right? For your time, because we being, some individuals are making arguments about things that they may not necessarily understand, but they're making the arguments to maybe mask some lack of knowledge about some e-discovery processes. Do you see that? I mean, you may be slightly biased in answering the question, but do you see that?
I think if people come to me with, again, knowledge and information, we're not going to have too many problems. Again, there may be substantive issues that we need to work out, but it isn't going to be are we entitled to that information at all? So if I ask, you say you're going to produce from emails, what about, are there any other communication apps that they're using? And we get you don't need any of that. That's not proportional. We're not going to be able to have a productive conversation. If someone comes to me and says, look, this is what we found out, and they use these two apps primarily, and we're gonna search those. There's one that some people use, but it seems to be really sporadic. It's really difficult. Can we hold off on that one? We're not trying to hide anything. And they give me some data to back up why it is more cumbersome for them to go and get that. I'm going to be much more likely to listen to that, and we can move forward from there. But when it's you don't need text messages, you don't need any of that, that's not proportional, and that's where the starting place is, then I think, yes, now we have to have 3 meet and confers about that, rather than being able to work through the issues quickly. So yes, I think having that sort of information would make things much smoother and more cost effective and more efficient, and build a lot of trust. as well.
I've heard you mention proportionality a couple of times in some of your answers, and I'm really curious what your thoughts are on the concept of proportionality. Is it leveraged more often than it should be? Is it just a blanket defense that people are using? How do you see proportionality? Do we understand it the right way? What are your thoughts?
I mean, I think even before the rule amendments that actually put in proportionality that specifically into the rules, we had a concept of that. I mean, I don't think there was ever, at least from the time that I've been here, where we said this is relevant and it doesn't matter how much it costs, we get it. Like I don't think that's ever been the case. We have always discussed burden and benefit and gone through some sort of proportionality analysis even before it was required within the rules. And so now that we do, I do feel like it's overused. It's just all of a sudden someone says, it used to be people would just say burden. Now they say burden and proportionality without anything to really back that up. And what makes it, why is it not proportional to the needs of the case? And people often just say the word without going through the actual analysis, or they just talk about burden. And then that's like the only portion of proportionality that matters. I do think it is overused and that not enough analysis goes into it.
It sounds like a lot of the things that Brandon and I are talking to you about, really, there's a common theme, a unification, if you will, and that really goes to education. And it's a great segue to something else we wanted to talk with you about, which is your involvement with NeLI. How did you first learn about NeLI? How did you first get involved with NeLI? And why did you get involved with NeLI?
I was trying to think about that, and I don't remember exactly. I had worked with Tessa Jacob, who's also involved with NeLI, and then I had met Robin probably through that and maybe the Sedona conference. And so I came and spoke at NeLI a couple of times and really had a good time with it. And Robin asked me to join the planning committee, and I was thrilled to do it. First of all, because I was the only plaintiff's person on there, and my goal is to try and have some member of the plaintiff's bar involved in all of the different e-discovery education, because I do think that there is an underrepresentation of the plaintiff's bar in the e-discovery conferences, and the education is so important. And I think from law school, again, there needs to be more e-discovery in law school and with attorneys. And I think that having that rounded education is very important, because if not, it's just an echo chamber of a defense side mantra. And again, there's nothing, I make it sound sinister, and sometimes maybe it is, but not necessarily. It's just they come at it in a different way, and they have a different perspective, but that's not the only perspective. And so it's really important to have the balance of the plaintiff side and a critical mass of plaintiff side folks, so that I'm not speaking for the entire plaintiff's bar, because that isn't practical and it's not genuine. I have a different experience than others do. So having a critical mass of the plaintiff's bar is crucially important to having an actual education rather than an agenda, which I feel like is part of just having one side talk about their positions on everything. And judges are at these, and so it is crucially important to have a balanced perspective at these conferences, that judges are getting educated too. I mean, I think it's, what is it? EDI they've been doing a judges education for years. And to me, that is shocking, since it is an organization that is 100% about the defense bar and the corporations that they represent. So I try and be involved in as many things as possible that is about education in e-discovery, where there can be a balanced perspective. I feel like it's my duty to be involved, especially if there are no other plaintiffs' attorneys who are involved. And Robin is fantastic, and she is tenacious, and we disagree on everything having to do with e-discovery. But we can still have these discussions and talk about it, and we respect each other. And same with Tessa. I mean, Tessa's amazing, and we've developed a great friendship. And though we may disagree on certain issues, we can still speak about them rationally and respectfully, and enjoy putting this together and have a common goal of wanting to educate attorneys and law students. And I really love the fact that UMKC is involved in this, and they've been so involved and such a great partner on this, and being able to involve the law school and law students, and they're so active in it, it really brings in a great perspective.
All the different conferences that we have out there in the discovery space seem to develop their own character over the years. They become this type of thing. You know, that's what you're going to get at this conference. When you think about NeLI, what sets NeLI apart to you and makes it different from some of the other big conferences that you see around the country?
Well, first of all, I love that it's in Kansas City, and I've really, like, out of all the years of coming to Kansas City, I've grown to really enjoy it. So I love that. And what I think is really unique about NeLI is there's a lot of there's mock hearings, mock negotiations. And that is, I feel like, such an interesting way to tackle the issues and make them more practical in being able to see, okay, we can talk about the rules, we can talk about these issues, but how does it really play out? How does it work in real life? And I really enjoy the fact that there are at least one or two sort of mock hearings or negotiations within NeLI. And I think that should be utilized more often, because I think it's a not only entertaining way of doing it, but a really good practical approach to understanding why it's important to know about these issues, rather than just sitting there and listening to people yammer on about it.
Leah, you have been a very thoughtful and instructive voice throughout this episode, and all the reasons why we wanted to have you come on came to fruition here. I think that you've brought out a lot of nuggets for folks to think about. Your perspective was very enlightening, and we really appreciate you coming on to the show today.
Thank you so much for having me. I really appreciate it. And I look forward to seeing you guys at NeLI this year.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in e-discovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of e-discovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.